Welcome, everyone. I'm Diane Drain, co-chair of the CLE, the ACBC CLE program, along with Lisa Thompson. We're here today to talk about taxes. Lisa's going to introduce our speaker, and then we'll go from there. Just a little bit of housekeeping up front. Please post your questions in the chat. Lisa will be monitoring them. And if they're relevant for the whatever Hubert is discussing at that time, then bring them up. Otherwise, you all know we take lots of questions at the end also. So this is just a heads up to our speaker. We may need you to stick around for a couple of minutes after the end of the hour. As far as your CLE certificate, it'll be posted at the end of the program. And the materials I will be posting a couple of times throughout the program, but they are available at the ACBC website. So acbc.org, go to resources, and you'll see the materials there. Plus, you'll also, by Monday morning, we'll see the video. It's available for self-study. We do not give you CLE certificate for the self-study. We only give it for live presentations, which you'll get here. So hopefully that covers everything. Lisa, all yours.
So everyone, I am super excited to introduce you to my friend Hubert Johnson, who practices all over the United States handling tax debt outside of bankruptcy. And I think that many of us have clients where, bankruptcy isn't, they don't need to file bankruptcy for any other reason, but they have bad tax debt. And we've all had those cases where they're not going to be able to make it in a 13 because their priority tax debt is ridiculous and they can't pay it off in 5 years. Or they're going to end up after a Chapter 7 with a lot of debt for taxes, and they're going to need to deal with it. And so Hubert's going to talk about all the different ways that that can happen. I know he's going to pepper the presentation with some tips and tricks and some things that he has seen. And I'm so grateful to him for teaching me and also teaching us about taxes outside of bankruptcy. So please put your questions in the chat. If I will pop on and interrupt him if we need to. And otherwise, we'll get them at the end. So Hubert, without further ado, there you go.
Thank you, Lisa. And I would say I'm not going to get thrown off by questions. So if you have questions, I'd rather, I'm very comfortable with taking them through as we go through the presentation. So just kind of diving right into it. Guardian Tax Law is a company I founded back in 2018. I've been doing this since 2009. Our main goal, and this is how we see ourselves, is that we're kind of a one-stop shop. Bankruptcy, they come and they're not your client forever. They come, they do the bankruptcy, and hopefully they move on and don't need you again. And that's how we look at tax debt resolution. So we help people understand and comply with their financial obligations and legal obligations to the U.S. government and states, mainly dealing with taxes. We do deal with some other issues. So we resolve debts with the IRS, states, SBA, and we're going to talk about that. We also play with FBAR cases, so foreign reporting of assets. And I've dealt with the DOJ, and I even had one case go up to the Ninth Circuit Court of Appeals. It had gone there through some very bad advice, and I was able to pull it back and deal with it on the district court level. But yeah, lots of fun. So part of what we do, and I want to emphasize this, that I take a holistic look at things. If I'm not operating in a vacuum, and I'm not an expert in everything. So I refer frequently to bankruptcy attorneys, CPAs, financial advisors as part of a financial team. And one of the best success stories I have is a good friend of mine, and I knew him from church, and he just told me, hey, I've got a big issue coming up. I just found out that my wife, who has been doing all of my taxes and my bookkeeping, she's not a bookkeeper. She was never trained in all this, warning bells. And it came out, he got audited and it ended up owing $250,000, $150,000 to the IRS, $100,000 to the state. And he had his own business. We stepped in, I lined up a business attorney, I got a CPA involved, I got a bookkeeper involved, and we took all of that stress off of his shoulders, kept them from hitting him with collection actions. He was able to go and focus on his work, and he doubled his crew size and just went to work, and within a year he paid it off, paid the whole thing off, and then he was able to turn around. He knew how much he was making, he knew what his income was, he knew what he needed to pay in estimated taxes, and he previously had 3 kids and his wife living in an 800 square foot home. He doubled the size of his home, landscaped his property, put up a playground for his kids, and just completely changed his life. And for us, working with other professionals is a goal, because I think it helps the client so much more. And again, that's some of our best success stories are where we've worked with plenty of other professionals. So these are the 4 main topics we're going to cover today. What can the IRS demand? What can states be demanded or demand? And also what's required in bankruptcy. And there's a lot of bad information that gets put out here. So we're going to go over tax collection alternatives, business taxes and how those are affected, the different operations, because this is where you get into a lot of the priority and secured debts. And then we're going to talk about a new area for bankruptcy attorneys that it's really opened up as the previous options have changed recently. We're having so many different changes. It's trying to stay on top of those. So I'm going to hit those one by one. So the first one, this is something that might be something everybody knows. There are plenty of people that don't. I talk to divorce attorneys all the time, and they don't have a clue about this. So when people question who's going to owe what, it's all based on their social security number. Each person has a tax account, and it's based on how you file your tax returns. So if you especially have a married couple, or if you have a divorcing couple, or you can be married and file separately and have one person owe and the other person not. So I had a case where this one gentleman, he was going to owe over $100,000. His wife didn't want anything to do with it, so to keep his wife happy and keep his marriage happy, he filed separately for that year. And the plan was to do an offer and compromise for his taxes, but do an installment agreement for hers because she had a lot more money and a lot more income at the time. So it's understanding how tax accounts work and how the IRS looks at who's liable for the taxes. Payment of future taxes, payment compliance is a huge thing. So again, you have to get in a place where you're not continuing to owe the IRS. And then you have payment resolution of past due taxes, which is you have to do the first 2 steps before you can go and actually resolve it. So filing compliance. What is filing compliance? And again, here, this is where we get how many returns need to be filed. We were talking about beforehand, IRS and state income taxes. You have business returns, trust tax returns, estate returns, all kinds of returns. And when you go to the states, you have sales taxes, withholding taxes, and people can get very confused about what needs to be filed and how to close out accounts, how to get current in them. And we were just talking about California, and I'm actually an attorney from California, so I can bag on California a bit. But they're notorious for filing for people that have either left the state, retired, gone to prison, had massive health issues. If they see your income drop off or you don't file a return and you were making good income, they can and often do go and file for individuals. So part of this is you want to make sure going into bankruptcy that everything's filed, you don't have any audits coming up, and everything's been closed out. So you're not going to have any surprises. Sometimes that happens regardless. I just had an offer in compromise where an audit popped up on an old tax return from 2018. We had no notice of it, didn't know about it. It happened after we had submitted the offer in compromise, and now the whole thing's blown up and we get a restart. I'm sure that's happened to some bankruptcy attorneys out there too. So the question is, how many tax returns do I have to file? There's plenty of bad information. If you call the IRS, they'll tell you 10 years. There's plenty of CPAs and tax preparers out there that will say 10 years. They're wrong. So interesting enough, this little slide used to be up. I've quoted it for years, if not more than a decade. It is now, it's been taken off. I mean, here's the link to it, but it's no longer visible on the IRS website as part of their Internal Revenue Manual, which is essentially their Bible. So the IRS can only go back 6 years. So if someone's telling your clients they need to file 10 years, again, that's absolutely incorrect. And currently it's only going back to 2019. So this is happened December 30th of this last year. And it was kind of funny, so I remember those stories. I had a revenue officer asking for a list of documents, and one of the things that he needed was to get all the tax returns filed, and he hadn't filed for the last 10 years. So he was asking for 2018 through 2023. So on December 30th, he could still ask for 2018. And we're going over what he wants. And I said, I'm not going to have him file 2018. And he said, well, I know, but I still have to ask for it for the next 2 days. Once January 1st happened, the older year dropped off, and currently they can only ask for 2019 through 2024. Anybody telling them otherwise either doesn't know what they're talking about, which is very common at the IRS. But when you get further deeper into their bureaucracy, the collections, the people that actually make decisions on the case, they all know it's 6 years. And I can't tell you, there's been law firms that I've started at, and they were doing 10 years. And I had to pull up this rule and say, you're hurting your clients here. So it's not common knowledge. Bankruptcy, typically the last 4 years need to be filed. So here's my question is, if you've got to file, sorry, I keep clicking on things. How do you get your clients to file? So, and if you owe during bankruptcy or throughout bankruptcy, you have to get them to continue to file or get an extension of time to file. It's all required. So I'm sure plenty of you have run into this where people file their returns, they start a bankruptcy, and then they don't continue to stay current. The IRS has made it easier than ever to get the information to file their returns. And that's one thing I'm going to really talk about. And then if they don't stay current, the bankruptcy can be dismissed. So how do you get the information to file older returns or even fairly newer returns?
Hey, Hubert, before you go on to that, we do have a question. Does the 6-year look back apply to penalties for failure to file also?
So you're not going to get those penalties until you file a return. So it applies to everything. So if you haven't filed for 10 to 12 years, those older years, it's kind of like a statute of limitations. Once those 6 years go away, you don't have to file them. They can't require that you file them. If you do file, then you owe everything. So I had a true story. This guy came in and called in, and he had filed 23 years of returns going back to 1996. He was so proud of himself that he gotten caught up with the IRS. All of that tax debt, that 10-year, it wasn't going to expire from 10 years from when they processed all those returns. But he'd already mailed them off. There's no way to unring that bell and pull those tax returns back. So again, be very careful on older returns, especially if you don't have to file. You're going to get hit with all the penalties, failure to file, failure to pay, accrued interest, all of that. So it really helps to find out which returns do I have to file. Now, did I answer that question?
So let me see if I understand this. So if I have someone come in my office and they haven't filed their tax returns from 2010, right? I should tell them, you don't do that because we're outside the 6-year statute of limitation. And if they did do that, so the IRS can't do anything to them if they don't file.
The older returns. Right now,
like
further back than
2019. Right. Okay. But if my client was like, no, I'm going to file them and they owe money, now they get hit with the penalties for late filing and the penalties for, and the taxes and all of that. And you start that 10-year statute of limitations for collection.
Right, and that starts as to when those tax returns are received. So he had taxes going back to 1996 that weren't going to go away till 2031.
Wow.
Well, this is in 21.
He didn't like talking to you, I don't think.
No, he didn't hire me. When I told him that, I said, look, I wish you would have talked to someone. I'm glad you're talking to me now, but I think he was so stunned. He got off the call. And yeah, I changed. So now when someone comes and tells me that, I'm like, okay, great. I don't burst their bubble so much, but.
We did get a question. How many years of tax returns does Arizona Department of Revenue require?
Great question. I'll give you the famous attorney answer. It depends. Typically 6, but states can go back further than 10 years. So I have one right now, and this is mainly when do you want to file older returns is when they've already filed for you and you're replacing a filing enforcement or substitute for return with an original return. So I have one where I'm working on a 2004 tax return with California to wipe out a balance that's been around all the way back then. So there are times to do it, but it's the exception. If you haven't filed and there's no balances for those years, let those sleeping dogs lie.
Excellent. Well, that handles the questions that we've got for right now. Continue on.
Not a problem. I love the questions. So IRS.gov, I have to give huge kudos to the Biden administration for putting this in place. It is very handy, especially when people they get all the scam letters, crazy calls, etc. I know there's a lot of computer illiteracy out there, but if you have someone that can work with you, you go to irs.gov, set up your account, you have to do the facial scan, date of birth, firstborn child, all that. But then you get full access to your tax records. So wage and income transcripts, tax return transcripts, account transcripts, and they were working on, so hopefully in the short future, they'll have notifications anytime there's a collection letter or anything happened on their case. So they can send an email through that portal directly to taxpayers. So I know CPAs that for every single client, they're having them sign up for irs.gov and set up a PIN. And so if you have a PIN set up through irs.gov, it is a huge deterrent to ID theft. And I'm sure you have plenty of people dealing with identity theft, dealing with scams, et cetera. I've seen it, and it's one of the biggest problems out there. So I can't recommend irs.gov enough. And for that reason, a lot of CPAs are forcing their clients to get on.
Could you expand on that just a little bit?
So you can, if you go to irs.gov, and I just need to change what I'm going to.
I think more of the protect yourself identity theft kind of issue.
If you could just let us know how the PIN works.
Right.
So when you set up an account through irs.gov, one of the options, and there's a lot of options in there, you can set up your own installment agreement, you can see what balances there are, but one of the options is to go and set up a PIN number, and you could do that previously, but it was by mail, it was clunky, it was more difficult. But when you set up a PIN number, if anybody files a tax return with your social, they don't have that PIN number with it, it will get automatically rejected. So it has to be you with that PIN number, and I've even heard of people using it for dependents. So again, it can really prevent ID theft. Just that PIN, you have to keep that safe, keep that secure, and don't lose it. But don't keep it on your computer either. So again, if you haven't played around with irs.gov, I would check it out. And this is, just general information to the public. See what's on there. There is a lot of great information, and this is one area that they're expanding services and making tax information a lot more available to the public. Now, what to do with that is a different question. But I think it's really good that they are making this available, and you can find out what's on. And I think a lot of people, bankruptcy attorneys, probably know about wage and income transcripts. Not so sure about the other ones. But I'm gonna kind of dive into that next if there are no further questions. So the transcript types, wage and income is exactly what it says it is. So you can get 10 years, the past 10 years with the IRS, all income that's been reported to the IRS is available on your transcripts. So capital gains, your W-2 information, 1099 information, any kind of sale of property, any major purchase gets reported, gambling's winning losses, crypto gets reported. So again, I even had someone, this is funny, he was my client because he liked to cut corners, and I was teaching him not to. And so he asked the question, even with crypto, are there on the dark web, are there cryptocurrencies that aren't reporting to the IRS? I said, sure, but you've already lost 100,000 through investing in bad crypto. You want to continue doing that? And he said, oh, you have a good point. So most things are reported to the IRS. Pretty much anything above board is reported to the IRS. The only thing they don't see is self-employed income. But if you have vendors or major clients, they very well might be issuing you 1099s. And the nice thing is that all of that information is there. If they need a file for the last 6 years, even go to older returns for the last 10 years, the IRS has all of that. And you can pull all of that through irs.gov, or any tax professional with a CAF number, enrolled agents, CPAs, tax attorneys can all pull that information fairly quickly. If you need income further back, you have to go to the Social Security Administration, and it's a pain to get information from them, but they have it. One key thing is the IRS does not keep track of state withholding, so sometimes you have to reach out to the states to get that information. Tax return transcripts, and I'm probably spending more time. It's the last 3 years of your tax returns. Line by line, everything that was on your tax return. But because there's so many tax returns, so much information, they don't keep it on file more than 3 years. So if it's great if you need to amend a return. If you need to, you should always get a copy of your return and keep that on file on hand. But more than 3 years back, they're not going to have that information. Tax account transcripts, we use this all the time. And they have tax return transcripts going back more than 10 years. So, and it usually stops around 15 or so, because by then most tax debt has expired anyway. There are exceptions, but if you're convicted of fraud, if you go to the DOJ, which I don't recommend, you can have a 40-year expiration date on tax debt. I've seen it, it's not pretty. So with account transcripts, it has the total balances, accrued interest and penalties, original assessed balances, which really helps if you're thinking of filing an original return, filing dates, which is very important for if it hasn't been filed 3 years prior or 2 years prior. In Arizona, I believe it's 240 days. I don't know I know there's a 240-day rule. That's not my cup of tea though. But audit examination dates for increases in income are all on the account transcripts. So I use and refer to account transcripts all the time. We pull out wage and income transcripts for clients all the time. But as far as knowing what's going on, the account transcripts is really handy. Other liabilities that won't show up on personal account transcripts are state taxes, business taxes. They fall under the state. You have to go to the state to get their information. Business taxes will be under an EIN. And there's times where I have people come to us and they've had multiple businesses and they don't know how many EINs they've had. I'm sure you've seen that as well. Sales taxes, treated very differently. TFRP, trust fund recovery penalties. We're going to dive into those more, but that's based off of payroll taxes. SBA loans is another big issue that we're going to be talking about. So this is, most of you probably know all about this. For if you're a bankruptcy attorney, this is nodding her head. And this is just kind of an overview, but this ties into why it can be very important and handy for your clients to use a mixture of services to best serve them. So unsecured debt, personal taxes, 3 years old, filed the last 2 years. And then you have the 240-day rule here in Arizona. Unsecured priority debt. So tax debt that's too recent. And again, if it's not paid, if you don't pay the interest on that debt in the bankruptcy, you'll owe it afterwards. Secured debt, property with tax liens, or where tax liens have already been filed on tax debt. Sales taxes, withholding and payroll taxes. So those are all treated as secured debt and generally not dischargeable in bankruptcy. So the interesting thing is, you don't have that separate treatment of these taxes when dealing directly with the IRS or states. They'll treat each type of tax can be treated a little differently, but when you're doing these resolutions, these overall resolutions, you don't have to. So for example, just some of the different types: hardship or non-collectible status, installment agreements, offer and compromise. Again, states vary greatly with what they offer. California has one of the best hardship statuses, and they'll put you in there for 6 to 12 months at a time and renew it fairly easily. Arizona, they don't really have a hardship status. They don't care that much. New York has no hardship status. If you can't pay on an installment agreement, they're not really interested in talking to you. We can remove driver's license suspensions that happen. I just did that in Maryland, but done it in New York, done it in other places where the Department of Revenue or of taxation will suspend driver's licenses. But what they offer really does vary greatly by state. Tax lien removals is something we can do. So are there better options? And just some ideas. If we have tax debt that's expiring soon, it might be handy just to be proactive or use our time wisely as to when we're actually going to file taxes or file for bankruptcy to let some things expire, especially if they're secured. Priority versus secured debts and other factors. So I just want to go over the different alternatives and how they could help your clients. So this is for the IRS. If you go into a hardship status, you can put payroll taxes. You can put payroll taxes. You can put business taxes, etc., into a hardship. They don't like to put business taxes into a hardship, but I've done it. It's 2 years of zero payments. There's no automatic review. So especially if someone that's elderly, and especially if they haven't filed anything, you can file all of their tax returns, put them in a hardship status, and then do a bankruptcy on everything else. You don't have to wait the 2 years to do that, because then you'll know they're taken care of, especially people on a fixed income. And so this is a recent change where either the tax debt goes away or their income goes up. But if their income doesn't go up, they're just going to stay in that status for years, well beyond the initial 2 years. With states, again, some of them have, California has 6 to 12 months at a time. There are other states that have hardship statuses. Some of the bigger ones, AZ, New York, don't. It really depends on the state. And sometimes it's a sob story, but I've taken sob stories to Arizona when someone was on a fixed income, ill, and they rejected an offer, a compromise, and a hardship status, and told me you have to pay up or else. No. Do we have a question?
Well, I was going to ask you if penalties continue to accrue while you're in a hardship status.
Absolutely. But when they expire, when the underlying debt expires, it all goes away with the debt.
So you could essentially be in uncollectible status and wait out that statute of limitations.
Yep.
So you don't necessarily need to be worried about those penalties.
No, it all goes away. I've got another funny story on that. This guy owed $25,000, called the IRS, didn't know exactly when the statute of when the they called a CSED, collection statute expiration date was. But we were going to set up a payment plan for this gentleman. He had assets and money to pay. So I called, went through the numbers, and found out that $10,000 was expiring in about 10 days. I said, okay, can we set up a payment plan on the other $15,000, because the first payment is going to be for 30 days. And the guy got all huffy, said, no, he has to pay this within 10 days. He needs to send in the check and pay this right away. I said, okay, great, I'll call you back in 2 weeks, and hung up. So I called back 2-3 weeks later and just set up a payment plan on the remaining $15,000, because once that date hits, it's gone.
Good to know.
Yeah. So that is definitely an option, and this applies across the board. The only thing that sales taxes is dependent on the state. So you have to have a hardship status with the state to be able to put it. The state has to offer a hardship status to try to put that in that status. Now, installment agreements, they come in all shapes and sizes. So someone can owe $1 million, and if their financials show they can only pay $1,000 a month, that's what they're going to get. They're going to get an installment agreement for $1,000 a month. Doesn't matter if there's tax liens filed. That doesn't matter if it's payroll liability. As long as it's under their personal Social Security number, under their personal account, we can go in and set up an installment agreement on their ability to pay, and they can pay just penny, a very small portion of the total balance. And when it expires, the rest of it just expires and goes away.
How do they determine what can be paid?
It's based on fund financial analysis that's based off the IRS Form 433A. So it's based on their actual numbers. It's based on IRS allowables that changes every single year. If you have more questions on that, I have plenty of videos on my website where I talk about that at length. So I probably have a series. I know I've done a series of probably 5 to 6 hour long videos on that topic. But that's where I get to nerd out and get in the weeds. So you can avoid or release tax liens and then do a bankruptcy with installment agreements. So if there's typically, if you have a case without tax liens, or even if you do have tax liens involved, if it's under 50,000, you can go in and set up a payment plan, and after 3 to 4 months of payments, you can get that tax lien removed and then file for bankruptcy. So 50,000 doesn't sound like a lot, but if you know tax liens are coming, or it's a possibility, you might want to jump in there and file for bankruptcy sooner. But there are other ways to release tax liens as well. They're not easy to
How-
release.
Well, how quickly do they do tax liens?
It completely varies. So as long as there's a tax debt, they can file, they have to issue notices of intent to file a federal tax lien. And then once they issue those notices, then it's pretty much open season. They can file them anytime. But there are certain actions that will trigger a tax lien. So if you put someone in a hardship status, tax liens are automatically filed. If you set up an installment agreement and the balance is over 50,000, they're automatically filed. So if you are trying to avoid tax liens, those are things to tell your clients not to do as you're approaching bankruptcy. And if someone has IRS collection actions, bankruptcy is a sure way to stop it right in its tracks.
So if you go into hardship status, like I go to the IRS, I can't pay, and they say, okay, well, you can be in hardship status, they're going to immediately hit me with a tax lien.
To protect the government's interest.
Playbook.
Yeah, but if they already have tax liens filed, it's not going to hurt.
Right, but I did not know that. That's interesting.
Yeah, so if you file for a non-collectible status or an installment agreement, and it doesn't meet their criteria under 50,000, and they want it set up on a direct debit payment plan to avoid the tax lien. But if tax liens are already in place, it's not going to affect anything. Okay. Offer and compromise. I like to compare it to Cinderella's slipper. Everybody talks about it. Everybody thinks it's great and it's wonderful and everybody wants it. Not everybody qualifies. So if you're trying to, and I've had one case in particular, someone came to me, they referred by a financial advisor that worked with his parents, and the parents said, you need to call Hubert. They called me up. He had been told by 2 different tax attorneys he didn't qualify. He had gone online to their offer and compromise. They have an offer and compromise program on irs.gov. You can see if you qualify by their criteria. It's a horrible program. I don't trust it at all. But we made a couple adjustments and got him to qualify, and we wiped out $80,000 with the $7,000 offer. The key here is you've got to fit the mold. And sometimes if you're trying to shoehorn yourself into an offer and compromise, if like Cinderella's sisters, if you're trying to cut off a toe or cut off your heel to make it fit, it probably isn't a good fit anyway. It's not going to work. I see some questions popping up.
Well, we had one about statute of limitations. I was going to let you get through offer and compromise first.
Oh, there's plenty to talk about with offer and compromise.
Okay, so the statute of limitations, does it expire even if there's a tax lien?
Yes. Tax lien does not affect a statute of limitations, or they call it a CSAD, collection statute expiration date.
So does the statute of limitations run from the time the tax lien is recorded, or does it run from the time the debt was incurred?
From when the debt was assessed. So when the IRS processed the return. So if I filed a return in 2000 and I owed $20,000, when would I file my 2000 return? In 2021. You always file by April 15th of the next year. So you always add a year to it. That's if they filed timely. And then let's say we're looking at bankruptcy, and so I owed $20,000 in 2020, but then I got audited, and in 24 they assessed another $40,000. That first $20,000 was assessed in 21, but this additional $40,000 from the audit was only assessed in 24, so it actually has 2 expiration dates.
So that first 20,000, if they put a lien on it at some point, it still runs from that original assessment date.
Right. the tax liens are just notices to the counties where they're filed with the county recorder, so to attach to real property. But they don't change the CSED. What will change the CSED is anytime the IRS cannot collect. For example, if someone's filed a bunch of offer and compromises, and I've seen people file 6 or 7, and all they do is kick that can down the road and give the IRS more time to collect on it. I've seen if you get put into if you're in appeals, if you're going to tax court, anytime like that, will extend out when tax debts expire. Bankruptcy is your classic one, extends out how long it will take. So if someone's in a chapter 13, which I've seen, the entire time they're in a chapter 13 and the IRS can't come and levy bank accounts or garnish wages, that extends out when that tax debt expires. So various things can definitely extend that time out. Any other questions?
Nope, we're good.
Okay. Back to the offer and compromise. If you're looking at chapter 7 and you have priority taxes, if you have sales taxes, if you have other issues like this, depending on the state, it might make sense to either do an offer and compromise beforehand, and then whatever's left over can be thrown in the bankruptcy, or the other way around. And I do this all the time regularly, not all the time working hand in hand with bankruptcy attorneys. If someone's going into bankruptcy, we'll usually ask them, who's really coming after you when someone calls? Because a lot of times if they owe taxes, they owe other debts. And if it's credit card debt, if they're getting a car repoed, their home repossessed, go talk to a bankruptcy attorney and do that right away. And there's times, one case in particular, and this one's kind of funny. Guy called, was going to hire us, was going to pay us $7,000 to take care of his case. He owned a car lot, and he had a revenue officer on his case. So again, they had demanded all kinds of information. He hadn't provided it. He was dragging his feet. And so I was talking to him and I said, look, he's going to come, he can come Monday with a fleet of tow trucks and bolt cutters and haul off every vehicle. And I asked him, are all of those cars yours? And he said, no, they're there on consignment. Even worse for him. They weren't his vehicles. And I said, well, didn't they ask for that information? He said, yeah, but I haven't gotten it to him yet. So to stop collection actions, he really needed, he really needed to file for bankruptcy. And so I said, call a bankruptcy attorney today. He called me back an hour later and said, the guy wants $20,000. I said, pay the man. I couldn't stop them from coming in and clearing out his lot. The next Monday, he was just waiting for, this has gone up to council, IRS council, for approval for the seizures. But you know, if someone waits too long, and there's plenty of times where if it's too messy, then they really need a bankruptcy. That's the best best option for them in the moment. So the nice thing about an offer and compromise, you can deal with recent taxes, TFRP taxes, withholding for payroll. You can be strategic about what you do first. And sales taxes can vary by the state. So with New York, they want sales taxes to be older, but I've done, I don't know, 10 to 15 different offers just on older sales taxes with New York successfully.
So Hubert, when you're doing an offer and compromise, like what is it that the IRS is looking for generally? Is it, I mean, are you just saying like, hey, we can pay you this lump sum and then we're done?
There's two ways to do it. The lump sum way is the ideal way to go. The other way is stupid and I never do it. That's my professional opinion. The other option is to do an offer where you're making payments for 24 months based on what the IRS deems as your collection potential. But if you miss a single payment, the whole thing defaults and you have to start at the beginning before you even know it's accepted. And very few of those make it through the whole process. Whereas with the lump sum, you don't have to, you have to pay 20% upfront. The other 80% isn't due until after they accept the offer.
So basically you would file your paperwork and say, I don't know, I'm going to use easy math. we're going to pay 100 grand, but you would need to send the IRS 20 grand with your offer and compromise. And
upfront.
then you get to wait whatever period of time. And then they'll say yes or no, and then you would pay the rest of it.
Correct.
And in your offer and compromise, are you arguing that like this is all I can pay, or like this is why it's reasonable, you're never going to be able to get this from anything else, that kind of thing?
It's based on that fund 433A form, and they have a special one for offers called 433A OIC. And it really is looking at your available assets compared to future income. So your monthly income subtracted by your allowable expenses, what the IRS deems is reasonable for your account, and all the way down to county and many examples. So,
and I'm guessing that's on your website as well.
The form isn't. It's too much
No,
fun.
but you're
Oh, on my YouTube channel, yes. Yeah.
I've
Same
been
thing.
posting that in the chat so people know where to go.
Yeah. And I have two
And while
YouTube
you're
channels.
I believe you told me this that I found fascinating too, that I did not know. While you're in the offer and compromise or in any of this, aren't you supposed to maintain your taxes? Like
Absolutely.
current.
Absolutely. And that's right now, if someone goes and submits an offer and compromise, the very first letter that they'll get, whether or not they need it, is a demand for estimated tax payments. So I could have someone fixed on a fixed income for Social Security, and they'll ask, are you still paying your taxes for Social Security, which is taxable income still? But they will make sure that you're not going to owe for the current year, or they will reject your offer within a matter of a month or two. And they'll kick it right back at you, which is why we work really hard to make sure everybody's filed their returns and they're current on their estimated tax payments. So they're on top of it, whether it be a business or an individual, that they're making sure. And that's with any program. If you continue to owe, you're going to continue to cause problems. Before quoted Jim Carrey in Liar Liar, when he has to tell the truth and his secretary calls in, your client has knocked over another ATM and needs your expert advice. And he yells into the phone, stop breaking the law, blank. So that's one of the big services we do, is we help people understand what their financial obligations are, their tax obligations to the IRS and state, and comply with those. Otherwise, they're going to mess it up, and they're going to be right back at our doorstep in a couple of years, which is what we don't want. And then for an offer and compromise, there's a 5-year rule. You have to file your taxes on time, any required taxes, and not owe again for the next 5 years. If you do owe, just pay it right away and you're fine. But you can't have anything go to collections again, or it will default the whole thing.
So if you get your offer and compromise approved, and then like the next year you owe taxes and you don't pay them immediately, it's gone?
True story. So I had a gal had a salon in the Bay Area, and it happened to be located right next to a part of a post office. So there was all kinds of foot traffic. She made plenty of business. She came to us from a different company where she had got an offer and compromise approved, and I guess she was too embarrassed to go back to them. So we got her back on track, got her paying estimated tax payments, got all her tax returns filed, got everything set up for an offer, resubmitted the offer, and as soon as we resubmitted the offer, she stopped paying estimated tax payments. You can drag a horse to water. And so the first thing they asked for were estimated tax payments. She couldn't get caught up because she had stopped paying months prior. And we tried for 1.5 years to get her on board and paying estimated tax payments before we eventually fired her, because if she didn't stop breaking the law, we couldn't help her.
Well, but what if they've accepted it? It's a 5-year forward. They're still going to look at it. 5 years going forward.
Well, they're not really looking at it. Nobody's monitoring it, but in the computer system, it will automatically kick that offer out and reverse the whole thing if they owe again and they don't take care of it. And I have to give the IRS kudos. They've actually done much better. Is when there are issues like this, they'll actually reach out to the power of attorney, or they'll reach out to the taxpayer. Hey, you have this small balance, or this popped up. You have to pay it, or the whole thing will default. They don't always do that, but I've seen them do that more lately. And so that's why we are very adamant with our clients. You can't owe again. Yeah, at least for the next 5 years, keep your nose straight. Why would you want to be back here and have to hire a tax attorney again?
So we've got 8 minutes.
Oh, wow. I better move on. Okay. Tax lien removals. So again, we talked about setting up an installment agreement. There's other ways to remove tax liens, incorrect tax liens, expired debt. Even if a debt expires, the IRS doesn't always remove it right away. Someone else's debts. I have one recently where someone had a tax lien on their property and it was their daughter's property, but the realtor accidentally put the mom's name on it. And so the tax lien hit the daughter's property, even though the mom had nothing to do with it. You know, bad move realtor or title agent. But you can, once they're assessed and it's over 50,000, it's very hard to do that. An offer in compromise will also remove all the taxes once successful and remove all the tax liens. So understanding when they're going to be filed or getting ahead of it if they're getting notices that they're going to get filed can definitely help. Business taxes, I'm going to kind of sprint through this. With the IRS, if the business is closed out and they're using an EIN for their business filings, the business can be closed out. And we're talking about income tax, payroll taxes, pretty much everything owed under the business goes away as a defunct corporation with the IRS. And we're talking hundreds of thousands of dollars can be closed out with the business that's failed. The only exception is with payroll taxes. Half of those can be assessed personally to the owners or responsible parties. And that's what I call trust fund recovery penalties, or TFRP penalties. When I go and I'm closing out businesses, filing a final or closing return will close out their filing requirement and essentially let the IRS know it's defunct and they can't be pursued for that. And I've done that many, many times.
When you say you close out the business, are you just talking about a final return? Or do you go so far as to cancel out the EIN?
So you don't have to cancel out the EIN, but you do need to close it. And it's very important to understand, don't just go reopen another business doing the same thing. The IRS is wise to that move. And I have one client that did that 3 times with the restaurant. Every time he racked up a tax debt, he just created a new EIN. And it snowballed, and now he has a revenue officer assigned to his case, and it's a big, giant mess. So don't do that.
Closing out, I mean, you're talking about just the final return.
Well, there's doing the final returns, but you need to actually close out the business, which also means you need to close out the state. And that's where it becomes more interesting. So that's exactly where I was going next. Here in Arizona, it's a corporation commission. Other states is the Secretary of State. And you have to actually get an article of dissolution that you can, if you have an SBA debt, you can take that. But that's the best way to close it out. Make sure you're not going to have any further issues with the state, with the IRS for defunct businesses. And you don't have to file bankruptcy on defunct business debt because it goes away.
So you're talking about when you say close out a business, it's final returns, both state and federal, and shutting it down with the regulatory agency that controls it.
Now, one caveat with that, the IRS, the debts go away. The states, not so much. When you close out a state, you owe, most of the state taxes are either sales taxes or withholding taxes. You can have corporate taxes as well. It's always better to pay off the state. And we started talking about this in the beginning. Those taxes aren't going to go away unless in rare circumstances like New York, you can do an offer and compromise and settle. But that's an exception to the rule. So most states, you have to pay off the state debt before you can officially close out the business, and often close out filing requirements. So California will still require that you file a yearly fee with an $800 or yearly return with an $800 fee attached to it, plus penalties and interest every single year until you pay off all your tax debt and close it out correctly. And in recent years, they have come up with a couple programs to try to ease the pain of that. But again, it's not easy. And if you're in that situation, I would definitely get help.
I'm going to make a suggestion here. This is far too important to cut off or to make you force through as quick as possible. To our audience, remember this is being recorded. I would suggest we let our speaker go ahead and finish it out as he feels, in order to flesh this out. Those who want to leave at 1 o'clock, I'm going to post your CLE certificate. You are welcome to do that. But let's go ahead and get the full value of his services while he's here with us today, because this is extremely important. So,
and I don't have that many more slides left. Want to talk about SBA, Small Business Administration, idle options. First one is business closure. So if you owe less than 200,000 for idle loans, PPP is 100,000, and you obtain the loan through an EIN, employee identification number, and you did not personally guarantee it, you can do what's called a business closure and go out and close it out with the SBA and walk away from the debt. The debt is still there. You won't be able to get any further loans, but as part of that process, at our firm, we shut it down with the IRS and state and make sure everything's closed out so you don't have to worry about any issues popping up later. And that's just one alternative if someone has SBA debt under 200,000 under an EIN. If they So again, this just kind of walks out what we do. We close up the IRS and state business accounts, get a dissolution of business from the state, and then apply for the business closure with the SBA.
So you do that first. So you shut down the business first.
Right, because they want that dissolution of business from the state.
So you're not asking permission from the SBA?
No.
I don't ask permission either, but I heard there are some folks that are asking permission.
The business is closed, the business is closed. And if they don't have a personal guarantee, again, They can only go after that EIN. If that EIN is done,
right,
there goes the debt.
And so when you're talking business tax accounts, you're talking final returns.
Right. So closing out with the IRS and then with the state, making sure the debts are paid off. And once that's done, then you can close it out with the Secretary of State or an Arizona Corporation Commission. So again, part of this, be prepared to show assets were not misdirected or taken out of the business for other purposes. People have asked me, hey, can I do this? Can I do that? I said, don't play funny games with this stuff. That's where, especially now that things are being investigated, not worth it. Okay. And then this is, I do this very quickly. This was the hardship accommodation plan for EIDL loans. It stopped on 3/19 of 2025. It read X. I've got a lot of information here. If you're bored, you can read through it, but I don't think this is coming back. So one of the big things, and the HAP plan really was used for a lot of businesses that had personal guarantees, where people couldn't afford to make the monthly payments. They could get a 2-year reprieve on payments, but now they can't do that. So I have plenty of clients where they can't afford the $2,500 a month. So I have someone that owns a restaurant, has millions of dollars in revenue every year, but they're struggling and they can't make these payments. Their only option is to then go for a bankruptcy. So either Chapter 13 or Chapter 11. And there's a lot of these. I have one right now that I'm trying to refer to a bankruptcy in Florida. I have one here in Arizona. I have a couple already that I've referred out in California. This is a new area. Since the Trump administration closed out the HAP plan, there's going to be a lot of businesses where their best option now is bankruptcy.
Really, I think it's their only option.
Yeah.
There is nothing else. There's no offer and compromise for EIDLs.
There technically is, but
Oh,
I haven't
okay.
seen anybody get it. We've
There,
made multiple applications. So
well,
yeah.
okay. There are offer and compromises for non-EIDL SBAs.
Yeah.
That is correct. But for EIDLs, there's so like if you have any of the SBA other loan products, there is an offer and compromise, but you have to go through the lending bank and they pretty much laugh at you.
Yeah.
I mean, I had one that I did, and I mean, is that your experience?
Yeah.
You guys are like,
They-
no, it's gonna work, and I'm like, no, it's not, and then it didn't. So
No, it's unfortunately that has been pretty much, and they're tightening the screws on this. So the fun part about this is now some of the options. So I kind of skipped that. That all of the tax debt was going to the all the SBA defaulted loans were going to the Bureau of Fiscal Services, and even that's changed recently, where it's all going now to the U.S. Treasury. So they're figuring that out too. So if you're looking at options in dealing with defaulted loans, a whole new government agency has it. They don't have it figured out. It's all happened in the last month or so. So it'll be interesting to see what happens there. But you can try to set up a payment plan, but the terms of the loans are so much worse once the loan defaults. Instead of 30 years with the SBA, now you get 8 to 9 years. The interest rate gets jacked up. It's a nightmare. So there are some options in dealing with defaulted loans, but they're not good at all. And most people, if they couldn't pay with the SBA, they're not going to be able to pay with a defaulted loan. I have had success with some cases of getting defaulted loans back into their SBA status, but they have to get on their normal payments and continue that. So again, that's why they had wonderful, amazing terms with the SBA loans, which is why everybody wanted them. But if you can't afford to pay, it really is get back on that status, pay the loan, or consider bankruptcy.
and I will tell folks that my bankruptcy colleagues is I filed 13s and 7s, and I haven't had a problem with discharging SBA loans. In a 13, I had the SBA show up at the 341, but as soon as we provided records and we showed that my client had used the money appropriately, then it was no big deal. And I don't think that there was a personal guarantee on it anyway, but we went ahead and listed it. I also just heard from a source today that is pretty reliable, that there's over 2,000 referrals to DOJ on fraud. I'm sorry, I didn't get to tell you this beforehand. For like fraud on SBA loans, and only 6 are pursued a year, more or less. And so what they were saying was that the ones that are pursued are the ones that are super egregious and the ones where debtors have lied. And so their point was, because I'm actually going to be speaking on this next week, their point was whatever you do is hit the ugly bat straight on. Like, okay, we did not, like 50 grand of this was used for X, and that wasn't appropriate. And so maybe do a carve out for, like non-dischargeability of that 50 grand or something along those lines, and just hit it head on. Because they said that they were really focusing on, one, you bought a Lamborghini. Okay, that's an easy one. But, or, like everybody went to Disneyland. But the ones where people just lied about it. So, because I really think that bankruptcy is going to be the only option for these. And you can file a 7 for them too.
Yep.
Anyway, do you want to show, like, did you get through everything, Hubert?
I did. That was my last thing. I do want to finish off real quick with saying if you have tax questions, we are very open to questions, you can email, you can call us, you can go to our website. But again, I have bankruptcy questions and I call Lisa or I call someone else. So if you do have tax questions or what about this or that, feel free to send me an email or give us a call and pick my brain.
So I have a question for you as far as preparing my clients to file. One of the questions on my intake is, are you current on filing your tax returns? About a fifth of them, no. So generically, I tell them, well, get your returns all done, and then let's file the bankruptcy. Is that not good advice? Let's say we've got 4 years of tax returns that have not yet been filed. Is there a full yes answer or no answer, or is it kind of compromised based on facts?
Well, as long as they had a filing requirement, I would get them filed. And if they're filed and then you file for bankruptcy right away, you just know those can't be discharged.
Diane, what I would do in that situation, because I have a lot of accounts that come with that, is don't file it. First, review it, because you're going to have to see, make the analysis of what would happen in that bankruptcy, or alternatively, what kind of deals can you be making out with the taxing authority based on the assets you're seeing? Because either you're going to file if you file those returns beforehand, which is a tragic thing to do, because now the IRS went from having an idea that there may be some claim or liability out there to actually now having an assessment, and they can actually start taking collection actions. If you do the returns after the bankruptcy, now you've got a final assessment that's post-petition. And under 507A8A3I, that's now a non-dischargeable tax in and of itself. Of course, if they didn't file it beforehand, it's a non-dischargeable. But that's the kind of analysis you need to be doing, because I'm not knocking CPAs and accountants, but they're not going to do that type of analysis, and it needs to be done. Sorry, Hubert.
No, that's great information. And that's classic, something a bankruptcy attorney would know. I don't know that. I don't deal with bankruptcy. So this is why the best cases have a financial team.
That's why it takes a village.
Yeah,
right?
Exactly.
Hubert, would you do me a favor and just flash that last slide? Do
Yes,
we have
absolutely.
a disclaimer on there?
Yes.
And now go back to your contact information so folks can reach you.
Any other questions?
Well, so there was one that I pushed off to the end, and everyone feel free to like pop on. And Hubert, I don't know if you have any, I'll tell you what the scenario is. If you file a Chapter 13 bankruptcy in the state of Arizona, the Arizona Department of Revenue will file pretty much within 24 hours a proof of claim that says your client hasn't filed taxes for, I don't know, 20 years. Like, it's amazing. Within 24 hours, you'll get this thing that says your client didn't file taxes in 2009. And you have, and they will estimate the taxes for you. In Pima County, it's $1,434.10. I don't know what it is in Maricopa, but y'all are a little bit higher. And so you get this proof of claim that is ridiculous. Like, I had one where my client was a child in 2009. So we had to do an affidavit that says my client wasn't old enough to file taxes, or my client lived in Michigan and didn't have to. And so that's what's going on with Arizona Department of Revenue. And then they object to your plan, which is what Alex Sanchez was saying, and on, different grounds. And so how long can they ask for tax returns? Because what we typically have to do is deal with it and either show them a copy of what we filed or file an affidavit or send them an affidavit that says we didn't have to file for these reasons. What is the deadline in Arizona? So perhaps we could say, hey, we did, you're past your statute of limitations, and we could object to the claim.
States don't have a hard limit. So again, the CSED was established by Congress, rules and regulations by people complaining about the IRS. our
So
state.
like we're out of luck in Arizona.
I see states go 10, like I said, 10, 15 years back sometimes if they're showing a lot of income or issues. So there's nothing hard and fast like that for the states. And it's not just Arizona, it's other states as well. My suggestion would be to get your own returns filed, showing when they started having income and close it up, or deal with it in the affidavits. But yeah, no, there's no hard and fast rule like that for the states. Tracy has a comment.
Nope, I'm just gonna be quiet. I agree with you, but people don't look at the 422066. I would recommend that statute. That's the statute of limitations that are impacted by a bankruptcy filing or any other stay. The other provision I would check is 507A8A unlettered, otherwise referred to as G. It's the last one, which is actually a tolling provision that was created for the state of Arizona in the bankruptcy code.
So I did hear from Arizona Department of Revenue, and I don't remember where I heard this from. But for what it's worth, they said that they don't have a mechanism to track down people if they haven't filed their returns. So when we file bankruptcy, we're basically saying, hey, and so if they don't have a return on file, they just say we don't have a return on file, and that's what you get in your proofs of claim. And so then you have to clear them. So
One quick note, if they filed in another state, you should be able to contest that very easily.
oh, I mean, we can write an affidavit, but
Yeah.
typically, I don't know anybody wants to pop in. My clients are like, I don't know what I was doing in 2009. Like, what? I didn't file taxes? I mean, some of it's easy, and then some people are like, yeah, I don't know what I had for breakfast yesterday. So,
Well, Lisa, one way of doing is to doing a check with the feds. They can do what's called the match off list check, which says, okay, did this person list an Arizona address for that tax period, or did they list some other type of location for that tax period? That's the
that's a
match
good
off list
idea.
will do it.
It's just irritating. It's one other thing that debtors council has to do.
The government has no cost associated with doing these actions, so they will take claims and you go, why are you doing it? It's not worth it. That's the question. Sorry, Hubert.
No, I
Do you
get
have a
it.
comment? Does anybody else have any questions? Pop on.
Can I give one warning, Lisa?
Go ahead. Thanks,
You-
Tracy.
The Department of Revenue with respect to the transaction privilege tax, there is no automatic responsible party liability. What they have to do is look to see if the business, when they were operating, did they segregate the taxes and collect it from the customers? And if so, what did they do with it? Did they not pay it back? The case on that everyone should be familiar with is Action Marine. But what the department is doing is twofold things. One is they're sending out a questionnaire where they ask the debtor or the taxpayer, whichever one you use, term you want to use, to say, answer these questions. And that's where it's ego questions. Who are you? Were you the owner of the business? Could you control what goes on? Did you have the authority to hire? Did you have the authority to fire? Did you have the authority to pick where bills were paid? Yeah, when they sign up the last one, now they're committing themselves to, okay, now government used this against me for the personal liability. The other thing that they will do is if anybody is trying to negotiate an installment agreement or some type of settlement, they're going to say, here's the affidavit that your client has to sign. And that affidavit says, by the way, I did collect, I did segregate, and I just didn't turn it over to the state. So I'm personally liable. Be careful. That's not a requirement to sign. You don't have to do it. I never do that. And I don't do the questionnaires. So from the bankruptcy side, if your client's coming in there and they had a business that's been closed and they should have been either paying TPT or collecting the TPT, depending on what they are, ask those questions because you don't want to find out about that when you're already in the bankruptcy.
I don't see those so much with Arizona TPT cases when I'm setting up installment agreements, but I do see the IRS do that absolutely with payroll liabilities.
Oh, I see that routinely with the TPTs. Routinely.
What's that?
I see that routinely with TPT, where they're doing one of those things, the state.
Yeah, I see it with the IRS all the time with 940, 941 liabilities, 944.
So we do have another question, Hubert. Can you speak to getting passport decertified from the State Department? Will a pending OIC enable passport renewal?
A pending OIC will not, but pretty much any other resolution will. So if you set up any kind of installment agreement, if you set up a hardship status, anytime you take your case out of collections, that will reverse a revocation or suspension of a passport. And now you have two different systems talking to each other, the State Department and the IRS, and they don't talk together very well. So it can take months once you have the codes in under the IRS that there's a resolution in place for that to be then transmitted over to the State Department. So again, the quicker you move on that to prevent it, you can expedite the process, but you essentially have to have an itinerary, flight plans. You have to have a lot of that in place to expedite that with the State Department and try to get them to move quicker to reverse the revocation or suspension of your passport. But yeah, that's something that we handle routinely. It's just getting some kind of resolution in place. An offer and compromise, once accepted, will take care of that. But right now, the IRS is taking 6 to 9 months on most offers. And if you have to appeal it, which we have to do more often than I'd like, that adds another 6 months, 6 to 9 months to a case. So that's a long time to wait. So I would do another alternative resolution first and then do the offer and compromise.
So if one wanted to get the hardship status, do they just like call up and say, hey, I can't pay you? Or what is the mechanism for that?
I'm going to go back to the 433A, that financial.
Oh, that's right. I keep forgetting about your fun form.
It's not my form, but it's the same information. If you know what you're doing, you can do it verbally over the phone. If you don't, the IRS can get plenty of bad information from you and use that against you. I've seen that happen plenty of times. I've had little old ladies on Social Security, and the IRS will tell them you have to pay $500 a month. They call us up and say, look, there's no way I can do this. And we get it through a lot quicker just because we know the analysis inside and out and what people actually what their rights are and what options they should qualify for.
So do we have any other questions, folks? Mark, what's your question? Papa.
Did you call me, Lisa? Okay.
Yes.
Hubert, my concern is I get a bunch of people with 10 years of unfiled returns, and they come in to file bankruptcy, and I say, well, the code requires you to file all your outstanding tax returns. And it's a common question at the hearing, did you file all your outstanding tax returns? Well, the client's telling me he hasn't filed 10 years of returns right to my face, and I'm putting him under oath, but under perjury that he's filed all his returns, but the accountant told him just to file the last 6 years. Are we getting in a slippery slope here anywhere where maybe we're fudging our statement under oath? Or I kind of took the position, if he goes to an accountant and they say, you got to file 6 years, and that's what the IRS requires, that I'm kind of relying on, hey, they're just filing what the IRS requires.
Well, wouldn't you modify that, respond as the attorney for debtor that this requirement is 6 years? After you confirm with your client, of course, they've filed the 6 years.
Well, I don't know if I want to get into it because I think they're going to ask you, well, wait a minute, do you owe more than 6 years or what are you trying to say here? And they say, yeah, I owe more than 6 years, but I didn't do those. Now, where are you?
Well, if you haven't filed your tax returns, technically you don't know how much you owe, but that's more of an attorney answer. So the citation I provided earlier specifically says that in collections, and it's actually directed specifically for an offer and compromise, but it applies to collections generally throughout the IRS, they can only ask that the last 6 years be filed. So that's why anytime you're filing more than 6 years, you're only hurting your client. Now, for bankruptcy purposes, there's no hardline statute that says you can only file 6 years, which is why the IRS tells people 10 years all the time. I was actually lecturing at a seminar in New York City with a regional manager and their supervisor, and they came up on the stage and corrected me in the middle of my presentation, which was quite rude. But and said, no, you have to file 10 years. 10 years. I said, look, it's with collections, it's only 6. And if you want the citation to, come to me afterwards. I was really surprised, but they weren't in collections, they weren't handling it. But to go and tell a bankruptcy judge, all they have to do is file 6. The argument is, look, that's all the IRS will require from them. Asking for more returns is just, an exercise in futility. But I actually was trying to help one client that was trying to pass a bar review. So she passed the bar, she's going through it, and as attorneys, you all know it's so much easier to get approved as an attorney before you've lived life. And so I explained they wanted her to pay business debt on businesses that were closed out, defunct, and nobody was ever going to chase this money. We actually did an offer and compromise on one of the businesses, but the other 2 businesses, the IRS came back and said, why are we doing an offer? She's never going to have to pay this. And I explained, well, there's State Bar of Florida wants it. And they said, we don't care. It's all closed out. And they didn't approve the offers.
Hey, Hubert, a question. Do you think the government could go ahead and make the argument under 28 USC 959, 960 that regardless of what the IRS says, these provisions say that you have to do everything in compliance with businesses, et cetera, and as the debtor, and therefore you have to file it that way under that argument?
Yeah, that's outside of my expertise.
I'm sorry.
No, good question. But I mean, that's kind of the point I was making, Mark, where it's not a hard, fast rule that says, look, 6 years is all you have to file.
Mhm.
In reality, in practice, that's all you ever have to file due to this one citation. But this is specific for offer and compromises, and it's also used for collections across the board. There's no hard and fast rule that says 6-year limit outside of dealing directly with collections with the IRS. So in a bankruptcy context, if they come back and ask for 10 years or why haven't you filed, that's something, I don't have an easy answer for that.
It depends.
It depends. Depends on your trustee.
So we do have one other question and then we'll let you go. It's if a client has the money to pay and they owe taxes, does the 6-year return limitation still apply, or will all returns still need to be filed?
Absolutely. The 6-year rule still applies. And I have had clients with millions of dollars, hundreds of thousands every single tax return. And we definitely use that 6-year rule. So again, there's no limit on it. If the IRS snoozes, that's why they only have a specific time to file an audit or examination. And 6 years is the most that I could stretch to, which is why they have that 6-year rule. So I have had plenty of cases where people would have owed a lot in tax debt. They had the money, etc. But again, the whole goal is the overarching thing. It's a legal principle that we don't want to let sleeping dogs lie. We're not going to dredge up the past going back decades and decades, unless fraud is alleged. If fraud, this is why you don't lie, you don't misrepresent. If fraud is alleged, then all bets are off.
So I think going back to Mark's question about the 10-year, I know they haven't filed, and the question from the trustee is just tell the truth.
Always.
Well, and it's also what question was asked.
Yeah.
Exactly.
I will play and pull all kinds of tricks with the IRS, but it's nothing. I won't tell them straight to their face what I'm doing.
Hubert, do you happen to, what is the citation that you're referencing for the 6-year
We go back
statute
to it.
limitations? Wait, you don't have all of this memorized?
No.
You have the fun form memorized.
I do have that form memorized, painfully so. Filing compliance right there.
So this would be in your materials. They're posted both on the website and they're in the chat if you want to get them.
Real quick though, the interesting thing about this, since I shared this in January, the IRS has now made it unviewable to the public, but it's still there and you can still cite it, but the public can't see it. And in practice, they're still following the 6-year rule. Absolutely.
Sneaky,
Sneaky, sneaky.
sneaky, sneaky. All right. Oh, wait. Is there a statute though, or is it just an internal policy?
It's based on the Internal Revenue Manual. So that's where most of the guidance is, which is based on the IRS tax code, which I don't read that. I mean, sorry. They give out guidance weekly, and each one of those is hundreds of pages, and you might find something, nuggets within hundreds of pages, but I don't bother reading that. That comes out every week. It's just too much. So if you really want to nerd out, if you can't sleep at night, go to irs.gov, pull up the weekly update. And those actually are the only things you can hang your hat on, because ironically, if the IRS gives out bad information, either verbally or even on their website, or even even a senior manager tells you something that's incorrect, they cannot be held liable for giving bad information unless it's in the IRM or in their weekly publishings.
Well, everyone, thank you, Hubert, so much. I always learn something when I hear you talk. And if you guys want to hear this again, or you want to reach out to Hubert, one, it's going to be posted on our website. Two, you have his contact information. It's in the materials. CLE certificate we posted. And we look forward to having you back sometime.
Yeah, my pleasure. This has been great. Thank you, everybody.
Thank you so very much. Okay, everybody, take care.
Bye, everyone.
Bye.